Hello everyone. My name is Zahra MOHAMEDSALIH and I am a law student at my fourth year at Sakarya University in Turkey. And I would like to do presentation with you. It's gonna be about the space debris. I will share the screen with you so we can start.
Yes, we perfectly see your screen. And by the way, you look beautiful, Zahra. I like your makeup. You look very
Thank you
nice.
so much.
You are welcome, dear.
So, hello everyone. I will discuss the issue of space debris from an international legal perspective, focusing on one main question: is the current international legal system enough to deal with space debris, or are there important gaps? So to start, actually, we need to understand the problem scientifically before looking at the legal side. The first question may be, what is space debris? So space debris mean all human-made objects in space that no longer work. This includes all satellites, parts of rockets, and small pieces created from explosions or crashes. These pieces, even if they are small, they move at very high speeds. Up to, we are talking about 28,000 kilometers per hour. So they can cause serious damage if they hit something. One of the most dangerous problems is called the collision cascade or the Kessler syndrome. This happens when one crash creates many small pieces, and these pieces hit other objects, causing more crashes over time. This can make some areas in space unusable. Moving to the legal issue, this danger does not only affect satellites, but also communication, navigation systems, and future space mission. Space debris is not just technical issue; it is also a legal problem that at the international level. So now let's look at the legal system. Space debris is regulated under international space law, mainly through the Outer Space Treaty of 1967. So, Article 1, outer space shall be used for the benefit of all countries and the considered the proving of all mankind. This establishes that space is shared domain. So, Article 1 says that space activities should benefit all countries and all people. This means that space is shared by everyone and all countries should help protect it. Moving to Article 2, outer space is not subject to national appropriation, meaning no state can claim authority over it. So Article 2 says that no country can own outer space. Article 7 or Article 6 states bear responsibility for all national activities in space, including those considered by private entities. So Article 6 says that countries are responsible for all activities in space, even if they are done by private companies. This is important actually because today many private companies work in space, as we know. Article 7 states are internationally liable for damage caused by their space objects, forming the basis for liability related to debris. So, Article 7 says that each country is responsible for damage caused by its space objects. This is the main rule for responsibility, actually, in space debris cases. So, however, there is a big problem, actually. These rules do not directly talk about space debris. They only apply to it indirectly through interpretation. So this leads to the first main criticism that there is no clear and specific legal system that deals directly with space debris. In addition to treaties, there are general principles of international law. Like this includes the principle of preventing harm to others, the idea of shared responsibility, and the protection of the environment, including space. But these principles are very general and not very clear, so they are not strong enough in practice. When we talk about responsibility, things become more complicated. In theory, countries are responsible for the objects they send into space, but in reality, it is very hard to know who is responsible for space debris. For example, after a crash, it may be impossible to know where a small pieces came from. Also, space debris still belongs to the country that launched it, as we know, according to Outer Space Treaty or the Liability Convention. Even if it is no longer works, this creates a problem because other countries cannot remove it without permission from this country launching state, even if it is dangerous. So there is a conflict between two ideas, protecting space and respecting ownership. Actually, another problem is weak enforcement. There is no strong international organization that can check if countries follow the rules or punish them if they do not. So the system depends mostly on volunteer cooperation, which is not enough for a growing problem like space debris. Critical analysis from a critical view, international space law has developed slowly compared to technology. Space activities have grown a lot, but the laws are still based on all situations that did not expect today's level of activity or private companies. So, to deal with these problems, some solutions are suggested. This include creating clear rules, building a special international organization, and improving cooperation between countries. But the main issue is not only making new rules, it is making sure that countries actually follow them. In international law, as we know, the problem is often not the lack of rules or something like that, but the lack of enforcement. In conclusion, the current international legal system gives a general framework for space activities, but it is not enough to deal with space debris today. The rules are too general and not strong enough, which creates a gap between theory and reality, let's say. So there is a clear need to develop international space law into a more detailed and stronger system that can protect space from everyone in the future. So at the end, we as legal professionals and those interested in space law Actually, I think we should expand our research and read more about this topic, and it's important in order to help protect outer space. So that brings me to the end of my presentation. Thank you for your kind attention, and special thanks again to Prof. Maral for inviting me today.
Thank you very much, dear Zahra. Your presentation was inspiring. And thank you very much for talking about this really important topic of nowadays. Thank you very much. What was the reason of your arising interest in space law?
Actually, after participate the Laxmanford moot court competition, it's make me get more information about this file and more attached with it. So that is the main reason.
Had a webinar regarding the space debris. We focused on more technical side in the previous webinar. Today, we will want to focus more on the legal side of the space debris. So my name is Maral, and thank you very much for joining us today. If we will look at the core international legal frameworks regarding the space debris, we see that our Magna Carta, if we can say that, is like a constitution of space law, the Outer Space Treaty, the Liability Convention, and the soft law instruments. So what does Outer Space Treaty say? States are responsible for all national space activities, including those carried out by private companies, which is really important nowadays, because in the past we usually saw that only the states launch the objects into outer space, but nowadays the things are totally changed. And we see that states must avoid harmful contamination of space. A launching state is internationally liable for damage caused by its space objects. And when we look at the Liability Convention, we saw that this treaty builds principles and explains how liability works in practice. It introduces two systems for damage on Earth or to aircraft. No need to prove fault. For damage in space, fault must be proven. And this is where the things become difficult. This creates significant legal uncertainty. And when we look at the international guidelines and standards like assault law instruments, we see that, for example, United Nations Committee on Peaceful Uses of Outer Space, Space Debris Mitigation Guidelines, ISO standards, ESA Zero Debris Charter, COPU's Long-Term Sustainability Guidelines. And all these are non-binding and they guide behavior but do not impose legal obligations. And why space debris is legally difficult? Despite this framework, several major challenges is existing already. For example, no binding definition. There is no universally binding legal definition of space debris. The United Nations describes its non-functional human-made objects in orbit, but this definition is not legally accepted across treaties, or we can't say that everybody just described the space debris this way. Second issues is jurisdiction remains with the launching state. Outer Space Treaty states retain jurisdiction over their space objects even after they stop working. This creates a serious problem. Removing debris without permission may violate sovereignty of another state. Difficulty of proving fault. In space, liability depends on proving fault, but in practice, when we look at this, collisions are complex, tracking is imperfect, and responsibility is hard to establish. Identification challenges. There are thousands of debris in orbit. In many cases, it's simply impossible to determine which object caused the damage. And rise of private actors. Space is no longer dominated by governments. Private companies now operate large satellite constellations, dramatically increasing congestions in low Earth orbit. This makes regulation more complex and uneven across jurisdictions. So this is our problems. And in the conclusion, the legal framework governing space debris is built on strong foundation, especially the Outer Space Treaty and the Liability Convention. Also, we got the Registration Convention. The established key principle states is responsible liability for damage and international accountability. However, they were created in a very different era when space activity was limited and state-driven. Today, we face crowded orbits, commercial activities in outer space, and growing environmental risks. As a result, major gaps remain. For example, no binding definition of space debris, difficulty in assigning liability, legal barriers to debris removal, lack of global enforcement mechanisms, and increasing complexity from private actors. For future, we like to require a strong international cooperation, clearer legal definitions, and possible new binding agreements regarding this. Without these developments, space debris will remain not only a technical issues, but increasingly serious legal and governance challenging. So thank you very much for joining us today.